Today, in the media conference with Lal Goel, which is brought to you by V4 News, Caru News, V4 Stream, Malnadu TV India, News Gaon se, Samvad Sarokar News, Bharat Post News, Gyan, and Organ Donation India Foundation. Our endeavor is to enlighten you with the current topic, and today's topic is not only current but very, very relevant. And the topic is public interest litigation, PIL. The term public interest litigation has been consciously borrowed from the American jurisprudence. As per the original plan, the purpose of introducing PILs in the USA was to provide a substantial amount of legal representation to the unrepresented poor minorities, citizens who were truly passionate about issues pertaining to the public interest, such as terrorism, road safety, environmental hazards, etc. No particular statute or act have been created to address the issue of public interest litigation by the judges who could interpret the intent of the public. The chief instrument through which judicial activism has flourished in India is public interest litigation, PIL, or social action litigation, SAL. Public interest litigation, PIL, refers to litigation undertaken to secure public interest and demonstrates the availability of justice to socially disadvantaged party, and was introduced by Justice P.N. Bhagwati. It is a relaxation on the traditional rule of locus standi. Before 1980s, the judiciary and the Supreme Court of India entertained litigation only from parties affected directly or indirectly by the defendants. It heard and decided cases only under its original and appellate jurisdictions. However, the Supreme Court began permitting cases on the ground of public interest litigation, which means that even people who are not directly involved in the case may bring matters of public interest to the court. It is the court's privilege to entertain the application for the PIL. One of the earliest public interest litigation was filed by Mr. G. Vasanta Pai, who filed a case in the Madras High Court against the then sitting Chief Justice of the Madras High Court, S. Ramchandran Iyer, after it was found the judge had forged his date of birth to avoid compulsory retirement at the age of 60, and his younger brother sent invitations to celebrate his 60th birthday. And Pai found evidence after photographing his original birth register, which showed his real age. Mr. Ramchandran Iyer resigned on a request from the then Chief Justice of India, Justice P.B. Gajendra Gadkar, as the case would damage the judiciary, and he had resigned before the case came up for hearing. This led the case to be dismissed as he had resigned. In December 1979, Kapila Hingorani filed a petition in regards to the condition of the prisoners detained in the Bihar jail whose suits were pending in court. The petition was signed by prisoners of the Bihar jail, and the case was filed in the Supreme Court of India before the bench headed by Justice P.N. Bhagwati. The petition was filed under the name of a prisoner, Hussain Nara Khatun, and the case was therefore named Hussain Nara Khatun versus State of Bihar. The Supreme Court decided that prisoners should receive free legal aid and fast hearings. As a result, 40,000 prisoners were released from jail. Thereafter, many similar cases have been registered in the Supreme Court. It was in the case of S.P. Gupta versus Union of India that the Supreme Court of India defined the term public interest litigation in the Indian context. The concept of public interest litigation, PIL, is suited to the principles enshrined in Article 39A, subclause A of the Constitution of India to protect and deliver prompt social justice with the help of law. Before the 1980s, only the aggrieved party could approach the courts for justice. After the emergency era, the High Court reached out to the people and devised a means for any person of the public or NGO approaching the court to seek legal remedy in cases where public interest is at stake. Justice Bhagwati and Justice B.R. Krishna Iyer, Advocate Shashank Dev, please mute yourself. Disturbance is coming. Please mute. Yeah, thank you. Justice Bhagwati and Justice V.R. Krishnan Iyer were among the first judges to admit PILs in court. Filing a PIL is not as cumbersome as a usual legal case. There have been instances when letters and telegrams addressed to the courts have been heard as PILs. The Supreme Court entertained a letter from two professors at the University of Delhi. It requested the enforcement of the constitutional right of inmates at a protective home in Agra who lived in inhuman and degrading conditions. In Miss Veena Sethi versus State of Bihar, the court treated a letter addressed to a judge of the court by the Free Legal Aid Committee in Hazaribagh, Bihar, as a writ petition. In Citizens for Democracy, through its president versus the State of Assam and others, the court entertained a letter from Sri Kuldeep Nair, a journalist, in his capacity as president of the Citizens for Democracy, to a judge of the court, alleging human rights violations of Terrorist and Disruptive Activities Prevention Act, TADA, detainees. It was treated as a petition under Article 32 of the Constitution of India. So today, to discuss this very, very important aspect, that the public interest litigation PIL, and because this is a particular litigation which is for the benefit of public at large, it is not for a particular individual or a particular advocate. So that's why we have taken up this subject today, and to discuss the integrity and the advantage and disadvantage of this public interest litigation PIL, we have a very eminent legal luminaries as a panelist with us. And I would like to invite my first panelist guest, and he is Advocate 𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒. Advocate 𝐂𝐀𝐑𝐔 𝐍𝐄𝐼𝐒 is a renowned social activist and Supreme Court lawyer. He is practicing law for last 42 years on the civil side. He appeared in Supreme Court and Allahabad High Court in several important cases. He is active on various social platforms of the city of Agra. He filed several PILs in Supreme Court regarding the RTI Acts, etc. Recently also, he filed petition relating to road safety. His large number of articles were published in law journals. His articles were also published in many newspapers on various subjects, including environment, RTI, culture, etc. He has varied interests, especially in RTI and environment. Welcome, Advocate 𝐂𝐀𝐑𝐔 𝐍𝐄𝐼𝐒 on our show. Advocate 𝐂𝐀𝐑𝐔 𝍍𝐄𝐼𝐒, today the topic is of interest of public as well as your interest, because you are one of the champion of filing public interest litigations at Allahabad High Court as well as Supreme Court of India. We would like to know from you about this in detail so that our viewers should know what is public interest litigation, their advantages, disadvantages, etc. So public interest litigation PIL, Advocate 𝐂𝐀𝐑𝐔 𝍍𝐄𝐼𝐒, please.
Thank you, Mr. Lal, for inviting me and for permitting me and giving me a wonderful opportunity to share my views on this important and ever-growing field of law and public interest. I begin with this, that whenever the courts involve or issue directions in a public interest litigation, the politicians start crying that they are interfering in the administrative works, in the government functioning. So first of all, we must consider whether judicial activism shown by the Indian courts is leading to a conflict between the interest of the government functioning, of the government functionaries, and that of the judiciary. We know that there is a separation of powers, whether it is judiciary, executive, or legislature. We have a division of the powers. Point is that when the legislature or the executive fails to perform its duty, then only the courts intervene. By showing judicial activism, they are not going to run the government. They are not going to legislate laws. They know their Lakshman Rekha. But the question is, when there is a violation of fundamental rights affecting a team which is vulnerable and which cannot come to the court, then why the court should not interfere? The courts are the guardians of constitution. our constitutional and legal rights, and if there is a violation, then they must interfere. Therefore, I would say that judicial activism is good for the health of democracy, because democracy, people's rights should be protected, they should be respected, they should not be crushed by those who are powerful, and the underprivileged and weaker sections of the society should not suffer. Therefore, judicial activism or the activism shown by the judges to take up issues of public interest is a very good sign for strengthening our democracy. Therefore, the outcry of the politicians that the judges are interfering in their work is not a correct allegation. The politicians must consider that whether they are performing their duty, whether they are discharging their executive actions in the executive field, that whether they are performing their duties properly, they are not. Then only the courts come and interfere. Now, coming to the role of the courts in PIL, I was just looking at the answer given given the Raj Sabha about the number of pending PILs in the Supreme Court. As on 31st March 2022, 2,884 matters in the form of PILs are pending out of 70,476 cases, meaning thereby the 4% cases pending in the Supreme Court are PIL. It shows that a large number of cases are there that way, because ultimately the matters that are entertained by the Supreme Court are found to have the element of public interest therein. But I would at the same time like to comment and say that the Supreme Court has the power under Article 32 to see that the fundamental rights of a citizen are not infringed. But often it happens that when we approach the Supreme Court says that you go to the concerned High Court first. Question is, when there is a violation of a fundamental right and it comes within the ambit of Article 32, then the Supreme Court should not hesitate to entertain the matter. That is one aspect that the lordships of the Supreme Court must consider, that they being the guardian of the fundamental rights, they need to see that it is protected, and wherever there is a complaint in the form of PIL that there is a violation of fundamental right, they should entertain such matter. Number two, the PILs filed in the Supreme Court are remain pending for a longer period. Once the Supreme Court finds that yes, it is a matter which needs consideration, then they should endeavor to decide it at the earliest. The delay in disposal of PILs is also harming the cause of the PILs. Therefore, they should be taken out of turn. They should be decided on the basis of priority. Thirdly, it is not only the PILs that an individual, a public spirited person who should file and it should be entertained. The courts do so also, and should do more, that they can take the issue suo motu. Ultimately, many a times people because of various constraints, money, maybe time, maybe other reasons, and avoiding the confrontation with the people in power, do not approach the court, and the interest of the public suffers. Therefore, the suo motu writ petitions should be initiated and should begin when the courts, through the media, through the newspapers, print media, through the electronic media, find that there is a cause or concern, then they must initiate the suo motu proceedings, and they should register it, and they can have assistance of amicus being appointed by them. Therefore, this aspect that suo motu proceedings must be initiated. For instance, yesterday 27 people have died in Delhi on account of a fire outbreak. Should we not initiate a proceeding saying that why the commercial buildings, why the residential buildings, why the institutional buildings do not have the proper firefighting arrangements? This is an issue. This is an issue which the Supreme Court must take in order to save it. If you look at on pan-India basis, we find that people generally do not comply with the fire safety norms. Therefore, I mean to say that the Supreme Court must also initiate suo motu proceedings, which can be a good source of great relief to the people and the weaker sections. As far as your comment that it is the court's privilege, I would say that it is the court's duty. It is not the privilege of the courts and judges to entertain or not to entertain. Once a petitioner, a public spirited person, establishes before the court that yes, there is violation of the fundamental right, violation of a legal or constitutional right, then the courts are bound and duty bound to entertain. Of course, the principle of locus, as you have pointed out, one must approach the court to get relief, redressal of relief. But the point is, if the people are weak or belong to the weaker sections and the public spirited persons come forward, then he must, the cause pleaded by him must be entertained by the courts. Therefore, it is not, I would say that it is not the privilege of the court, but it is the duty of the court, once it is established that there is an infringement of fundamental right or a legal right affecting weaker sections or underprivileged people, and ultimately the decision is going to have the salutary effect on the public. Now, coming to the PIL petitioners, what kind of petitions are being filed? Recently, there was a petition relating to Taj Mahal, that the 20 rooms that are being closed, they should be opened. It should be found out whether it was a Hindu temple or no temple, and that petition has been dismissed by the Lucknow bench of the Allahabad High Court. Point is, the petition, the public interest litigation should not be misused. Number one, there should be a legal or a constitutional enforceable right. We cannot enter in the domain of policy making. The judges are not the policy makers. The policy maker sits in parliament, in the legislative assembly or council. They make the policy. The judges are there to enforce the constitutional and legal right. Therefore, the petitioners of public interest, they must understand, and people must understand, that unless there is a legally enforceable right, their so-called cause may not be entertained by the courts. Therefore, there should be a legally and constitutionally enforceable right. It should not be a policy matter. It is also found that people file PIL without proper research work, without proper supporting evidence, documents, and they just swayed away by emotions. They file it, and ultimately, not only the matters are dismissed, but they are also penalties are also imposed. Therefore, those who want to take up the issues relating to public, they must also do the proper research work, properly obtain informations under the RTI Act. They should collect the documents, and with the support of, on the strength of such documents, they must lodge their PIL. Not that just writing, just thinking and approaching the court, unless it is supported by the documentary evidence, and you are able to make out a case of infringement of fundamental right or a legal right, you may not succeed. There should not be a personal interest of a PIL petitioner. That is a disclosure, that is a declaration that a petitioner is to make. He should not have a hidden agenda. He should not have. He should not use that PIL as a ground to have his personal interests served. It should be a public purpose. It should be a real public purpose. Bona fide intentions must be there. And in the if a particular cause is already pending in the court in the form of PIL, then there is no occasion for another petitioner to file another PIL on the same subject. Of course, he can become an intervener. He can come before the court to assist the court in the pending matter. Therefore, those who file repeated petitions while already a petition is pending, that may not be entertained, and it is not a good practice also. I would like to just mention a few petitions that I filed and what is my experience. I filed 5 writ petitions in the Supreme Court relating to enforcement of the rights of the under the RTI Act, which is a sunshine law and which empowers the citizens. 2 petitions were against the rules of fixation of application fee by the Legislative Assembly of UP and Legislative Council of UP. What they arbitrarily fixed the application fee as rupees 500, while the central government has fixed only 10 rupees as the application fee. Matter came up before the court. Court allowed the petitions, and they fixed 50 rupees at the application fee. They also reduced the copying fee, which was fixed by the Legislative Assembly and Legislative Council RTI rules to be rupees 15 for a page, while it is only rupees 2 for the central government rules and then generally the state government rules. Other petitions that I have filed under the against the in respect of the RTI Act is, one is online hearing by the information commissions. You have to run all the way to Lucknow in case you are in UP, and to see that your matter is heard, and you find that it is adjourned. You come back. Therefore, to effectively enforce your right to appeal or right to make a complaint to the RTI Information Commission, what we pleaded before the Honorable Supreme Court is that we should be given an opportunity of online hearing, and that has been entertained. One is that against all the high courts of the country, where they generally require that you have to send hard copies of application for seeking information. We said that it should be online facility should be there for moving the applications, and that has been entertained. One is which has been recently entertained by the Supreme Court is that there should be proper disclosure on of the information relating to public bodies on its website, because most of the websites are very scanty. They don't upload the information. People have to run for getting information by moving RTA applications, spending money, and they are not. They have to take all the pain for that. And that has also been entertained, and their prayer has also been made that there should be a third-party audit. Meaning that by these 5 5 PILs entertained by the Supreme Court, that show that the courts are quite sensitive. If you make out a case, they entertain. Recently, I have also filed a petition in the Supreme Court relating to traffic rules, that there should be electronic surveillance of the national highways and state highways in terms of the recently enacted parliamentary law on the Motor Vehicle Act, Section 136A. That application, because there was a matter pending already there, as Raja Sikaran of 2012 matter, the court directed that my petition be treated as IEA, and it be registered as IEA, and I was given liberty to raise all grounds. That IEA is yet to come up before the court for issue of notices. But at the same time, I would say that Allahabad High Court has also been quite energetic, quite responsive. I just sent a letter to the Chief Justice of the Allahabad High Court asking that we should be given online hearing. That letter was treated as a letter petition, registered as a writ petition, PIL, and they decided and they said that they would do it so, according to the infrastructure. Meaning thereby a simple letter sent to the Chief Justice was treated as a writ petition by the Allahabad High Court. Recently, we also filed a petition against the public park where the things are very mismanaged. There is dirt, garbage, not proper stray animals, weed, Prosopis juliflora, and all this and that. And the court has passed a beautiful order, an impressive order, and directed the state government to submit its plan. But at the same time, I have some sore experience also that I moved an application OA in the NGT, and in the NGT, the court relating to the the ground taken in the application before the NGT was that all those public parks which are located in overexploited groundwater zones, they should not be permitted to extract water from ground, and they should irrigate the parks with the treated drain water or STP, like what order has been passed by the Delhi by NGT regarding 6,800 public parks. But the NGT did not entertain that application, saying that you are not very specific. And therefore they did not entertain it, though I specified it that all those public parks which are located in the overexploited groundwater zones. A civil appeal was filed in the Supreme Court. Supreme Court also did not entertain it. Sometimes the judges, the tribunals are not that sensitive, and they don't understand the implications also. Either we are not able to convince them, or they are not able to understand whatever the situation may be. But the public cause, to approach in the PIL, they spend their money, they spend their time, they do a lot of efforts in preparing the petitions and filing it. The judges should take it in right spirit that if we have a cause, it should be entertained. Our pleadings may be incomplete, maybe not that accurate, but if the cause is there, that should be entertained and entertained. Judges, in all, public interest litigation is a good way to see that the underprivileged and weaker sections come for interest is protected and guarded. People who cannot approach the court, the public spirited persons can take their cause, just cause, reasonable cause to the courts, and it can be looked into by the courts. But the courts need to entertain such matters which are filed with bona fide intention, with good intentions, with a reasonable cause. Ultimately, approaching court is a very costly affair. There is a prohibitive cost, rather, I would say. Therefore, the judges must understand that poor people can't approach. And there is always a fear of the people in power that they can victimize the weaker people who approach the court. Therefore, the strong people who are public spirited, if they approach the court, matter should be approached. The matter should be entertained. The government must also not victimize the applicants who file the public interest litigation. The government must also take it as in the good spirit. But of course, the bureaucrats think that it is a petition against them, while it is a petition against the system. They should also introspect that they must change their functioning, which will ultimately improve the position in the society. People will get benefited, and they will get what is legally due. But of course, there is a conflict of interest. People who gain from such situations which are not good for the society, they have a conflicting interest, and that interest needs to be suppressed. No person should be allowed to gain from the weakness of any section of the society, and they must, and our endeavor must be through public interest litigation also, that the benefit reaches to the last person standing in the queue. With these words, I close my statement, and I hope that the courts entertain public interest litigation in the right spirit, and good cause are not denied, and bureaucrats and the politicians take PILs as a means and as a way to see things improved in the society. Thank you very much, Mr. Lal.
Thank you very much, Advocate Jain, for giving details about the PIL, about your own experience. And what Advocate Jain said, first thing he said that once a PIL is filed under Article 32, it should be dealt by the Supreme Court. Supreme Court should not direct them to go to first to High Court, because it's a matter which is of great public importance. Secondly, he said that the Supreme Court should do the 𝐂𝐂𝐑𝐔 cases as far as the public interest is concerned. Like he has given the example of yesterday's unfortunate Delhi fire, where so many people lost their lives. And it is only after such type of fire that some inquiry comes up. But why these types of fire clearances not being given to all the buildings existing all over the India by the fire department? That Supreme Court should clear and give some direction on that. According to Advocate Jain, court, it's not an obligation of the court, but rather it's a duty of the court to hear PIL. He is very, very clear about this. He says there are misuse of the PIL, and he has given example of this Taj Mahal PIL, which was filed and was dismissed by the Lucknow branch of Allahabad High Court. He also said that the judges are not the policymaker, but they are protecting the rule of law in the country. He says PIL should be filed where the public interest is involved, not by emotionally charged people who just go with the emotions and file the PIL. He also mentioned that the bona fide cases should be there if you are filing a PIL. And he has given his own experience about the RTI, which he has filed 5 PILs, and for online hearing, RTI Commission should hear about the reducing of the fees, etc. So he says the PIL is against the system, not against any particular bureaucrat or against the government, against the ruling party. So the government and the bureaucrats should take it in a right spirit and take it that it is a public interest and try to solve those problems so that the public interest can be solved and can be solved. Thank you very much, Advocate Jain. I'm thankful for you that although you are so busy, but you said that you will give some time. If you allow me, then I will ask the questions in the last, or you want me to ask the question right now, as you say.
If you permit me to answer now, I will be thankful.
Okay, because I know that you are quite busy preparing the case, and you have last moment you have allowed me to.
No. It's always a delight for me to participate in your webinars. Yes. I also keep learning from what is interacted in the webinars.
Yes. Okay, so my first question goes to you is, you says that a politician should take the judgments of the court in right spirit. Recently, rather the Minister of the Law mentioned something about Lakshman Rekha. Don't you think the political parties, when the PILs or any other cases are in their favor, they just come and on the media, they say, oh, our laws are such, and the judiciary is so high, and it's vetted our decisions. But whenever judiciary gives something which is not suitable to the ruling party, then they talk about Lakshman Rekha. So PIL, when we are talking of PIL, and recently one PIL was dismissed on the ground that it was filed by a political party, while you are saying that even the court should take suo motu. So my question to you is whether we should frame some laws, rules regarding the PIL so that everyone should know who can file, who cannot file. Secondly, the politician should understand once the judgment has been given by the Supreme Court, if the law minister will start commenting on that judgment, then what will be the condition of a lame person? If he will also or she will also start giving their judgments, then what will be the position of this PILs and the Supreme Court? Advocate Jain, please.
Thank you, Mr. Lal. First of all, talking about the Lakshman Rekha. The judges also know their Lakshman Rekha. But when they are convinced that there is violation of a constitutional right, violation of the rule of law, they interfere. If you file a public interest litigation, you find it that it is so tough to persuade the judges to accept your PIL. They don't encourage people filing PIL. They don't accept PIL so easily. If you will find the record of the Supreme Court, you will find that 95% of the PILs are rejected. Therefore, the judges, I will say, know their Lakshman Rekha, but only when they are convinced that, yes, there is a violation of the rule of law, they interfere. The politicians must appreciate that ultimately the Supreme Court, as the custodian of Constitution, is working for the benefit of the masses. And merely because it doesn't suit to the ruling party, or the ruling party thinks that that their superiority is being in some way subdued, they should not allege that the courts are violating or courts are crossing the Lakshman Rekha. Secondly, coming to the question whether there should be law for defining the contours of a public interest litigation, I would say that the Supreme Court, through its judicial pronouncements, has defined the contours, defined the limit, and again it is laying down the laws, limits, and permanency of the application, that by limiting it, by making a codified law, probably we will stop the growth.
I think Advocate Jain's network has given the problem, so no problem. So thank you, Advocate Jain. You have given the answers which we wanted, although one answer is incomplete, but it's what we can do. It's a technical hitch everywhere in India, so we have to face. So thank you very much. Now I would like to invite my next panelist guest, and he is Advocate 𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒. Advocate 𝐂𝐂𝐑𝐔 is practicing in Supreme Court, New Delhi, and various high courts of the country for over 20 years. He has been appearing in the courts for public causes besides commercial litigations across country. He appeared in more than 50 public interest litigations, which includes health issues, education, environment, aviation issues, etc. He has also raised the issue of free testing of COVID-19 to all citizens in the private as well as government labs across the country as petitioner. He has also raised the issue of regulation of airfares by way of PIL in Delhi High Court. He has also raised the issue of Shaheen Bagh protest in Honorable Supreme Court on the ground the fundamental rights of common citizens should not be violated, and several other issues which are in the public domain. His life is dedicated to millions of masses who are in need of the justice. Welcome, Advocate 𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒. Advocate 𝐂𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒, first of all, I must say that you are the champion of champions of PIL, because you are always talking and for the cause of public masses, and that is why you have filed so many PILs and you got success of many, which you are going to tell your own thing. But as far as you have already heard what Advocate Jain has mentioned, he has given all the details. He has given the plus side. He has also given some some interested parties misusing the PIL like Taj Mahal, etc. But he says also mentioned about the government and that if this is against the system, not against the particular ruling party or particular bureaucrats. Now we would like to know your views on public interest litigation PIL. Advocate Shashank Devsudhi, please.
Good morning, Mr. Lal, and good morning, our co-panelists. First of all, Mr. Lal, you have taken a very appropriate subject, the public interest litigation. Mr. Jain had quite exhaustively elaborated all the aspects of the public interest litigation. And we should not go into the intricacies and, the thinner, finer aspect of the public interest litigation. I will explain you the very fundamentals of the public interest litigation, from where the public interest litigation originates. The origin of the public interest litigation comes from the violation of fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution of India. If any rights are violated, any individual can approach to the High Court or Supreme Court, as the case may be. However, the public interest litigation implies a litigation for the protection of the public interest. This is an important concept in the law, and it was first introduced by V. Krishna Iyer. The seeds of this concept of the public interest litigation was sown in 1976. In Mumbai, Kamagar Sabha versus Abul Thai, where the unregistered association was allowed and permitted to file a writ petition under Article 32 of the Constitution of India. And thereafter, Husainara Khatun, P.N. Bhagwati also played a very important role in introduction of the public interest litigation. And subsequently, there is explosion of the public interest litigation. I must say to you that the public interest litigation is now working as an important instrument for a social change. It is working for the welfare of every section of society. It is a litigation which is non-adversarial in nature. It is a remedial litigation. People go to the court for the remedy, and it must be without any kind of dispute that there is a violation of the fundamental right. What Mr. Jain was saying, that the court should entertain a public interest litigation, court should deal with the human rights issues. See, should is a very deceptive word, and directive principles of the Constitution of India are full of should. And that should be the guidance to the government to enact a law. But unfortunately, the directive principles of the state are not being implemented because it is normatively non-justiciable. The fundamental rights are only normatively justiciable. So therefore, there is a distinction between directive principles and fundamental right. PIL can always be filed for the enforcement of fundamental rights. And the mechanism for approaching to the court for the violation of the fundamental rights are enshrined in the Constitution of India in Article 32 before Supreme Court and Article 226 before the respective High Court. But whether the public interest litigation is becoming a tool for a social change, this is a $1 million question. It is my experience that the public interest litigation is no doubt being entertained by the Honorable High Court and Supreme Court in appropriate cases, but the ultimate result and ultimate outcome of that public interest litigation, it takes years to come. And by that time, the entire purpose of the filing public interest litigation is defeated. No doubt, as you are also aware, and Mr. Jain had also stated that there are 3 types of public interest litigation. One is the letter petition. You can write simply a letter to the Supreme Court and it can be entertained, and the Supreme Court will pass an appropriate order. The second is a suo motu. Even the court can file a public interest litigation. And the third is the individual public spirited individual like Mr. Jain and myself and the other people go to the court for the enforcement of certain fundamental rights. So there are three types of public interest litigation. But what is the most important thing in the public interest litigation? Because the court normally has a perception that as public spirited individual is coming for some kind of publicity, personal publicity. This is the normal concept, the normal, thinking of the most of the court, and the public interest litigation, even though it is in the interest of public, it is dismissed. My question is, I pose a question. Even if some person, a public spirited person, go to the court for a personal publicity and raising a very good point, I think the court is fully justified to issue a notice and take an action. It should not be dismissed because it has come from the wrong person. I think the issue is more important than the person. So the court must understand the value of the issue which had been raised in the petition. So this is the one aspect of the matter. The second aspect, normally, if the public spirited person go to the court, there is a tendency to impose a cost from the court. I understand. If the matter is a frivolous, it will be from the face of the issue which had been raised in the writ petition. Any layman can come to the conclusion that a particular matter is a frivolous. Forget about the court. Imposition of cost will not deter the PIL being filed in the court, because this is not something which should be normally done. There must be a deterrent law. If the frivolous matter will be raised, a strong action will be taken against any XYZ person, then there will be deterrent, and the no person without any kind of purpose go to the court for the enforcement of fundamental rights. Because the cost is not a deterrent. There are violations. For example, I am telling you, you go to the road, every day there are thousands of challan being issued for the violation of traffic. This is not a deterrent. It is enrichment of the purse of the government. So deterrent should be like that, like Taj Mahal, as Mr. Jain said. Somebody has gone for a public interest litigation. It is a frivolous from the very issue which had been raised into the public interest litigation, and the court has rightly dismissed it. Some person in the recent months had gone for expansion of Quranic verses from Quran. This is from the subject matter itself, it is a frivolous. Forget about the contents of the public interest litigation. So the frivolous petition can be evident from the very face of it, because public interest litigation basically has been introduced for the downtrodden people. Because when the constitution of the country had been framed, the constitution maker might not have foreseen the occasion for the violation of the fundamental right, and there was no express and specific law for the enforcement of the fundamental right, and therefore the public interest litigation was coined, that if there is no law, where the people will go. And hence this public interest litigation mechanism has been very effective at the time of crisis, at the time of disaster, at the time of critical situation. So the very purpose of public interest litigation, that if a particular rights are violated, definitely anyone can go in the High Court and Supreme Court in a capacity of a representative person of the public. The expression public interest litigation has been borrowed from the American jurisprudence. Any matter where the interest of the public at large affected can be redressed by filing a public interest litigation in the court of law, such as terrorism, food safety, environmental issues. There are so many issues. But majorly, And fundamentally, it is coming from American jurisprudence, where it was designed to provide a legal representation to previously unrepresented groups like poor, racial minorities, unorganized consumers, and citizens who were passionate about the environmental issues, etc., etc. So, in our country, rights are being violated every day. And I think normally, Mr. Lal, every day there should be thousands of public interest litigation in the High Court and Supreme Court. You step out from the house, you will see the violation of rights. For example, Mr. Jain had said that the court are dismissing the public interest litigation even though he is a genuine. So Mr. Lal is himself an affected person. And for that also public interest litigation should be filed in the court, that why you are dismissing the petition. I mean regularly. So I'm not casting any aspersion on the court. What I'm trying to say that like there are several landmark decisions which have been made by the petition filed in the public interest litigation, like Bangabandhu Mukti Morcha versus Union of India, Supreme Court order for the release of the bonded laborers. In Murli S. Dogra versus Union of India, Supreme Court banned smoking in public places. In the landmark judgment of Delhi domestic working women versus Union of India, the Supreme Court issued a guideline for rehabilitation and compensation for a rape, compensation for the rape on a working woman. Vishakha, popularly known as Vishakha versus State of Rajasthan. Supreme Court has also let down the exhaustive guideline for preventing sexual harassment for a working women in the workplace of a workplace of a particular woman. So therefore, these are the public interest litigation which has been a benchmark petition, and benchmark decision had been given by the Honorable Supreme Court, and definitely it played an important and pioneering role in the evolution and the development of the public interest litigation. But definitely, if there is an advantage, there are disadvantages also, because the public interest litigation is being filed for rivalry, out of rivalry also. And it is quite common to see every day newspaper, television, that the public interest litigation is regularly and routinely filed for the purpose of harassing people also, because it is a motivated public interest litigation. And there must be some mechanism to understand whether it is a motivated and it is not motivated, because the court cannot foresee each and every circumstances in which the public interest litigation has been filed. So what I am trying to say, that public interest litigation is no doubt a very good tool for bringing a social change and bringing a parity between the poor and rich people. Secondly, the public interest litigation must be filed in a proper spirit, and if a particular individual is trying to misuse this platform of the public interest litigation, the mechanism should be let down, that a heavy, stringent fine must be imposed, so that the message should go loud and clear to the society that if anybody can misuse this forum, definitely a strict action should be taken. And the third thing which I am trying to say, there should be mechanism also, and there should be public interest litigation for that also. If whatever issues which had been raised into the public interest litigation, and finally the decision had been made by the court, that must be implemented without any kind of delay. It is not like one day news. It should be news for every day, that if a particular individual, a particular decision has been taken in the public interest litigation, it must be implemented, because right now we do not have any kind of mechanism in the court, either High Court and Supreme Court, that if any decision has been made, the court will supervise its implementation. You have to go in the contempt of court. And again, there is a litigation. So therefore, the public interest litigation, to be successful, there must be a proper mechanism, a proper rules and regulation. I think it will be a very dynamic, evolution of the legal jurisprudence in our society. And this Disaster Management Act, Mr. Lal, one thing I must add to you: the Disaster Management Act, the right of the civil court, the district court, have been prohibited. Because they cannot, pass any kind of order, because district court are normally dealing with the adversarial nature of dispute. So the High Court and Supreme Court had been given the power to pass an order during the prevalence of Disaster Management Act. So there was explosion of the public interest litigation, and I'm telling to you, there are lots of good decisions which had been made during the COVID-19, but I have no hesitation in saying that those orders which had been passed during that period of time has not been implemented, and the court is absolutely, have a part to play in this. The court should come forward and tell the government why a particular order is not being implemented despite the direction had been given, why the contempt petition should be needed to be filed. So therefore, the public interest litigation can be effective when there should be a mechanism. Unfortunately, the public, even though there is a mechanism, but this mechanism is without oil, this mechanism without petrol, because there is no life in this mechanism. Because if the systemic functionary are dead, no law can prevent you or protect you, sir. So the protection of the public interest is no doubt important, but the protection of the institution is also important. And the protection of institution can be possible if each organ of the state, like legislative, executive, and judiciary, they are functioning their duties in a defined mode. They should not overlap. They should not really interfere in the other domain. Then the democracy will be working and it will help the society. So therefore, I personally believe in the end that no doubt public interest litigation is a wonderful instrument in the hands of the common people. They can approach, but he has been limited by so many problems, so many exigencies. So there has to be a dynamic tool, and the public interest litigation must be breathed life into it by bringing about a required changes. And I feel that public interest litigation can be potential of bringing about a huge change, a monumental change in the life of the common people.
Thank you, Advocate Shashank Sudhi, for giving your views. And what Advocate Sudhi says, that first thing is that the PIL is basically for the violation of fundamental rights. We have to understand this thing. Whenever there is a fundamental rights violation of any individual, someone can definitely file the PILs. But he also mentioned that because of the sometimes the judges feel that this PIL has been filed because of the personal publicity. According to Advocate Sudhi, if the cause is correct, if the cause is really in the public interest, whether Mr. X has filed or Y has filed for their public interest, for their private interest, publicity, what difference it makes, one should see for the cause. He also mentioned that those who are filing frivolous or false PILs, there should be a strict action against them. And he has also mentioned about like Taj Mahal PIL, which has been filed, and although he says that it is rightly dismissed by the Honorable High Court, but he says until unless there will be a strict punishment to all those who are doing this, there will be no deterrent, and they will come up again with some other such type of frivolous PIL. But one point which he has made very, very important is that the public interest litigation is a news for a day or two. What about the implementation? And who is going to see the implementation? And that is where our judiciary is lacking. They must see that the implementation of the order of the PIL should be done. And why the petitioner should come for the contempt again, why not the respected Honorable High Courts or the Supreme Court should come forward and take suo moto action against if there is no, the orders were not be implemented. And he has given the examples of COVID, that during COVID time, the judiciary has done very nicely, gives very good orders, but are they being implemented? According to Advocate Sudhi, no. Many of the orders is still pending for the implementation, for which he says the High Court or the Supreme Court should take the actions directly. Thank you very much, Advocate Sudhi, for giving your very, very straightforward views. I am sure today our viewers are getting enriched by the legal luminary who are giving their views on PIL. Thank you very much, Advocate Sudhi. Now, I would like to invite my last but not the least panelist guest, and she is Advocate Anita Mahapatra. Advocate Anita Mahapatra is an eminent lawyer and partner at Attorney Alliance law firm based out in Delhi, having more than 24 years of working in various industries and fields, out of which 12 years in the legal field. Being a daughter of an army officer, she had an opportunity to her schooling in various states of India. She was active NCC cadet and marched on Rajpath in the year 1992. She was awarded silver medal in NCC. At present, she is helping most needy women who are the victims at the hands of domestic violence, sexual harassment, rape, molestations, dowry, and property issues by providing free legal services. Apart from her profession, she is active marathon runner, a fitness freak, a passionate dancer, and theatre personality. Welcome, Advocate Anita Mahapatra on our show. Advocate Anita Mahapatra, you have heard what Advocate Jain as well as Advocate Sudhi has mentioned about the PIL. You are also taking causes and you are doing free of charges, giving free legal services for the sexual harassed women, rape, molestation, dowry, and property issues, the needy women or the victims. So you are also doing a public interest, taking a public interest cause. We would like to know your views on public interest litigation, PIL. Advocate Anita Mahapatra, please. Please unmute. No, please unmute. Yeah.
Yeah, good morning, Mr. Goel. Good morning, Mr. 𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒. Good morning, all the viewers. Today, am I audible?
Yeah, please. Yeah.
Okay. Today, you have chosen a very good topic, which would interest public. So it's a public interest litigation. The topic is public interest litigation. However, as Mr. Jain and Mr. 𝐂𝐀𝐑𝐔 𝐍𝐄𝐖𝐒 have filed many PIL, I have not filed a single PIL till date. So there are various reasons behind it. However, I don't want to get into all these things. I just want to say my opinion, my views on what is PIL and why it should be, initiated before the court, and who can file, who cannot file, what should be the subject matter. So I would like to, I want to know, I would to convey to the people, they should know what is their rights. So I would say PIL, actually, this is not defined in any statute. There is no act, there is no statute where PIL is defined. It has been interpreted by judges to consider the intent of public at large. So PIL is the power given to public by courts through judicial activism. So PIL is not like my rights are infringed, or say my violations, my rights are being violated, I'm the victim, I approach to the court, I file an PIL. No, you cannot file PIL for infringement of your own rights, seeking for your rights. PIL is filed in the court is for the protection of public interest, like the issue of pollution, terrorism, then road safety, construction hazards, etc. So there are various areas where public interest litigation can be filed, such as violation of basic human rights of the poor, content or conduct of government policy, compel municipal authorities to perform a public duty when they are not doing their duty, violation of religious rights, or many other basic fundamental rights when it's being violated. Like in one case, Supreme Court opined the right to live is fundamental right under Article 21 of the Constitution, and it includes right to enjoyment of pollution-free water, free air for full enjoyment of life. If anything endangered or impairs that quality of life in derogation of laws, a citizen has a right to have a recourse to Article 32 of Constitution of India for removing the pollution of water or air, which may be detrimental to quality of life. Now, if you see PIL files in 1960 and 1970s, the concept of litigation in India was still in its rudimentary form and was seen as private pursuit for the vindication of private vested interests. So litigation in those days consisted mainly on some action initiated and continued by certain individuals, usually addressing their own grievances and problems. So there was very little organized efforts or attempts to take a wider issues that affected classes of consumers or general public at large. However, all the scenarios changed during 80s with the Supreme Court of India led to the concept of PIL. Supreme Court of India gave all individuals in the country and the newly formed consumer groups or social action groups an easier access to the law, and then introduced in their work a broad public interest perspective. A first reported case of PIL in 1979 on inhuman conditions of prisons and under the trial prisoners, Hussain Nara Khatun versus State of Bihar. I think Mr. Jain also has stated about it. Now, the PIL was filed highlighting the plight of thousands of under trial prisoners languishing in various jails in Bihar. These proceedings led to release of more than 40,000 under trial prisoners. The right to speedy justice emerged as a basic fundamental right which had been denied to these prisoners. Now see, who can file PIL? It's an individual, it's an organization, NGO, to protect or enforce a right owned to him or them by the government or on behalf of a section of society who is disadvantaged, who is oppressed, and is not able to enforce their own rights. And against whom PIL can be filed? It can be filed against state, it can be filed against central, state government, central government, municipality authority, then local authorities within the territory of India, and which is under the control of government, but not against any private party. So mainly whosoever falls under the ambit of Article 12 of Constitution of India, that can be the party, such as the government and Parliament of India, the government and legislature of each of the states, or local authorities, other authorities within the territories of India. So private party, when it can be included in PIL as a respondent, after making concerned state authority a party, then a private party can also be included. Like if there is a private, for example, if there is a private factory in Delhi, which is causing pollution, then people living nearby or any other person can file a PIL against the government of Delhi, Pollution Control Board, and also against that private factory. Not PIL cannot be filed against only private party alone, right? So that is some criteria which has been mentioned by Supreme Court. Well, I would say PIL is a boon as well as it's abuse of law. Boon because in PIL, vigilant citizens of the country can find an inexpensive legal remedy because there is only a nominal court fee fixed involved in this. On the other hand, of late, many of PIL activists in the country have found PIL as a handy tool of harassment, since frivolous cases could be filed without investment of heavy court fees as required in the private civil litigation. And deals could then be negotiated with the victims on stay orders obtained in so-called PILs. Well, abuse of PIL has become more rampant than its use in genuine causes. With the view to regulate the abuse of PIL, the Apex Court itself has framed certain guidelines. So court now ensures person who is approaching court is not coming for personal gain, not for private profit, not for political profit. So court should not allow its process to be abused by politicians and others to delay legitimate administrative action or to gain political objective. So public interest litigation is working as an important instrumental of social change. Like my both panelists agree to this statement. It is working for the welfare of every section of society. It's the sword of everyone used only for taking justice. PIL has been used as strategy to combat the atrocities prevailing in society. It's an institutional initiative towards welfare of the needy class of the society. In one of the PIL, bonded laborers were released. In other PIL, smoking was banned in public areas. In one PIL, guidelines for rehabilitation and compensation for rape on women was issued. So exhaustive guidelines for preventing sexual harassment of working women at workplace was issued. So, PIL plays a very, very important role in our society, due to which society gets guidelines on various aspects from time to time. Now, just like I mentioned in POSH Act, how POSH Act emerged. This act is the result of PIL in the matter of Vishaka versus State of Rajasthan. Judgment passed in this order recognized that sexual harassment is a clear violation of fundamental constitutional rights to equality, non-discrimination, life, liberty, as well as rights to carry out any occupation. And the guidelines passed in this judgment was mandatory to incorporate in every government and private organization. Similarly, in MC Mehta versus Union of India case, which was filed in 1988, civic authorities were lashed out for allowing untreated sewage from Kanpur's tanneries making its way into the Ganges. Also, at least 250 towns were also ordered to put sewage treatment plants. 600 trannies were asked to shift and relocate out of the city. Large number of industries were closed down by court. As a result, millions of people have been saved from the effects of air and water pollution of Ganga Basin, covering 8 states in India. This is called PIL. In one PIL, in Parmanand Katara versus Union of India, Parmanand Katara, he was an activist. He filed in PIL in Supreme Court to give justice to death of scooterist who was knocked down by a speeding car. Doctors refused to attend to him and directed that he be taken to another hospital, which was around 20 kilometers away. Now, SC passed an order that preservation of human life is paramount importance. Every doctor, whether at a government hospital or otherwise, has a professional obligation to extend his or her services with the expertise for protecting life. And in Nirbhaya case, guidelines was passed to set up fast-track courts in all rape cases. It was not before. In 2012, all rape cases will be decided within 9 months. It happened due to PIL was filed. So instead of dragging case for years, the verdict is out in 9 months in all the rape cases. The fast-track court was set precedent in such cases. So I would say the list of PIL cases in India have brought a lot of changes and amendments. PIL cases laws in India are of great importance to the working of judiciary, and PIL cases are thus needed to be encouraged as it can bring huge change. But at the same time, I would it is also imperative to say that some guidelines, some policies, some laws are already set there, and which is not being complied by the authorities, by the public. And then when PIL is initiated and the judgment is passed, then it was complied by the public, by the authorities, by the government. So this has to be curtailed. If already guidelines is there in their manual, if policies are there, law is there, we don't obey that, then again we file a case before a Supreme Court, and then they pass the order, and then we follow. Why? So it's a abuse of law, and it's a wastage of time of the judges. So that's what my views on PIL. Yeah, thank you, Mr. Goel.
Thank you very much, Advocate Anita Mahapatra, for giving your views. Although I will highlight only one point which you have mentioned about the Vishaka case, the POSH guidelines, but that what Advocate Sudhi has mentioned about the implementation. And one case recently about the CGI, the committee was not formed even in the Supreme Court when we are talking about the Supreme Court. So where is the implementation? If there is no implementation even in the Supreme Court, then how you expect that these PILs of any use for a small persons, for a poor or a underprivileged? Yes, they will be implementing all laws. But what about the powerful people, even like the Supreme Court? So it should be obeyed and implemented by in their spirit with everyone, not that they are more powerful or they are the judges, so they should not have those things. Anyway, thank you very much for giving your views. Now I would like to ask my question. First question goes to Advocate Sudhi. Advocate Shashank Sudhi, my question to you is, why Supreme Court has made the rules or the what is to be done about the PIL. Why the Parliament has erected a law, an act? Why not in PIL? All the things should be in the act, which will clarify each and everything, how the PIL has to be done, who can file PIL, what are the punishments if you are filing a false or frivolous PIL. What you say about this? Or you think that the whatsoever directions every time judges are giving, that is fine. But one side, the advocate Jain mentioned that they are not the courts are not the policy maker. But here, the court is acting as a policy maker. Why not the Parliament or the legislature? They make the policy and give this enact a proper law. What do you say about this, Advocate Sudhi?
Mr. Lal, who says that the court, are you hearing me?
Yes, yes, please.
Who says that the court is not making a law? Who says that the court is not legislating? Every day the court is passing an order, and that is the law. You know, the Supreme Court passes a decision that is the law, and it is a binding under Article 141 of the Constitution of India. So if the Supreme Court says that I am not legislating, I think perhaps you need to go behind this, right? And I disagree with the Supreme Court, right? Every day interpretation is being done and the new law is being let down, right? How can Supreme Court say that actually it is not making a law? I am not here to make a law. Right? You had forgotten the Visakha? You know, see, every day I'm seeing, you know, I can't able to understand, you know, what is this, right? Anyway, I'm not going into that because it is not my domain. My domain is to discuss. My domain is not to argue. And there is a difference between discussion and argument, because argument is meant to, you know, what is right and what is wrong. And discussion is what is right, right? So we are here, what is right. So what I'm trying to say to you, that public interest litigation is no doubt a very good tool if there should be a mechanism. And if there should be a mechanism, the court has also mechanism to see whether the direction given by the court is being implemented or not. For example, I am telling you, I am a crusader, and I have filed various public interest litigation 3-4 days before. I have occasion to appear before Delhi High Court and said, my lord, you have given a direction and that has not been implemented. The court said, I am not here to implement. It is for the state to implement. I have abruptly said, what is your role then? You have to protect the Constitution. I said that the illegal pathological lab are doling out and providing the fake diagnostic report, and that report is a crucial report because the entire treatment of patient are based upon that report. And if that report is not correct, what kind of treatment, my lord? Then he tried to argue like anything. Who is your petitioner? Your petitioner is a pathologist, and therefore there is a motive into it. Maine bola, be that it may. But this is an important aspect from which the society is suffering. And he imposed not 1 crore, 1,000 crore on petitioner. I told in the open court. And the judge was totally speechless. And the judge who was saying to me that I will impose a cost had given a direction to the Delhi government. ICMR, Ministry of Health. So what I'm trying to say, I am not really disrespectful to the judge, but I am disrespectful to the sentiment and, you know, kind of temperament from which, you know, an individual is suffering from, because we are the part of the, you know, society. The judge is also part of the society. And for example, I mean, if somebody is going to the court and some publicity is made, what is wrong with this? I mean, you are not giving fees. And if some publicity by raising a public issue comes, I mean, I should not be jealous about it. The court should not be jealous. Court should appreciate that individual. So my point, Mr. Lal, I'm just trying to say to you, public interest litigation is a phenomena which had brought a civilizational change in every aspect of human being, particularly the disadvantaged, downtrodden, and the person who is having no access to judicial forum. So, no doubt by that way, public interest litigation is undoubtedly, without any kind of doubt, pluses and minuses, brought about a change.
Okay.
So this is my thoughts on this.
Okay. Thank you very much, Advocate Sudhi. Now, Advocate Anita Mahapatra, you mentioned that you have not filed any PIL, and you also mentioned that you are not filing their reasons, but you have not given any reason. But I will tell you, being the chairman of Organ Donation India Foundation, I wanted to file a PIL because more than 5 lakhs people, official figure, otherwise unofficially more than 10 lakhs people are dying every year, which works out to be every minute, even if we take the official figure, every day about 1,500 people, or every minute one person is dying for want of organ. And because the laws in India are different than the laws in other countries, and in other countries, the mortality rate is very, very low. And we are almost in the bottom of the table, if you say, the highest mortality as far as organ donation. But I could not file because when I discussed with the legal numeraire, they say that there are 28 plus 9, 37 states and UTs. You have to make everyone party. It means you have to serve the notice to everyone. You have to make so many copies. And they say that it will cost several lakhs of rupees. Now, filing a PIL with the several lakhs of rupees, if you will file and spending, and then they says, then they says there is no guarantee that you will get any relief in this. As Advocate Shashank mentioned, so many PILs have been filed and they've been thrown out. So I do not want to go for that. My point to you is, Advocate Anita, is there any reason why you have not filed? Because you are a crusader yourself. You are taking causes, you are giving free services to the needy and victim women. Why you have not filed any PIL? Can you give any reason for that, Advocate Anita?
Yeah, Mr. Goel, it's a very nice question. However, I don't want it to reply to your question, but because you have asked me in open forum, so there is no question to back out. I have to reply. So there is no specific reason. Now, I'll give you a small example. There was a petitioner who filed in Madras High Court a petition. He says that retirement age, we should decrease the retirement age, right, from 60 to 59 years, because there are a lot of unemployment in India, and let other people should get opportunity. So his petition was dismissed with cost. But did he come for any for his popularity? He had some concern in his mind, and he just wanted to raise before the court, and maybe it was allowed, maybe it was not allowed. But why the cost was imposed on him? Cost should not be imposed on him, because he's a free citizen and he could come to the court.
Advocate Shashank, please mute yourself. Sorry, please mute. Yeah, please go ahead.
So he was talking about some rights, and he was thrown out by the court by imposing the cost. So I have a lot of things in my mind. However, it's not that I'm afraid of cost. Like you also said, there are a lot of many parties I have to serve. But remember, we don't have to serve. It can be served through email also. You can, of course, make a party, plenty of parties, and you can email that email by the copy of your petition sent to the respondent through email is deemed to be served. So you will not be, it is not highly costly for filing pay, because there is no specific, fees to be submitted in the court for PIL, only a matter of ₹50. And I will support you to file PIL in your case, not an issue. But yes, I will not file any PIL as of now. There is nothing in my mind.
Okay, thank you very much, Advocate Anita. So viewers, we have seen today the public interest litigation, PIL, which is a boon, as our experts have mentioned very, very clearly, it's a boon. And it's for the so many decisions and orders have been passed by honorable high courts and Supreme Court for the advantage of underprivileged, advantage of the rape victims, pollution, environment, and still few people are misusing it just for their namesake, not for publicity, but there is a motivational PILs that should be barred. And as one of the our panel experts says, that they should be penalized heavily so that they will not try to come again to the court with some other such type of frivolous PIL. But otherwise, if we will say that, if we must say that the PIL is a boon, only thing is that the government, my personal view is the government should come out with a clear legislation themselves, let them the court will interpret. But here, what is happening, government, because whosoever is in ruling party, they will not like to have this PIL, because PIL are always against, as the panelists mentioned, is against the government or the state government or municipality. So they never want to encourage the PIL, but the PIL has saved this country in many, many cases and has enlightened as well as given the power to the underprivileged. So thank you very much. And today's program has been live telecasted by V4 News.
Mr. Lal,
yeah.
Mr. Lal, one thing I must say to you.
Yes, please.
That you have said that the organ, the transplantation, you are doing a wonderful job. I am seeing it. But you have never discussed this issue with me. And I am telling you, you discuss with it. I will raise it before the proper forum, because I am doing a lot of matter relating to health, right? And I'm telling you, actually, I am guided and determined by one word of BG Justice B. Krishna Iyer. Judicial activism gets its highest bonus when it's ordered by some tears from some eyes, right? So always discuss. I'm telling you.
Okay, thank you very much, Advocate Sudhi and Advocate Anita, for attending our show as well as giving your views. And thank you very much, Advocate Jain. And thank you all the viewers for watching our show. And today's program has been live telecasted, as I told that it's live telecasted by V4 News, Caru News, V4 Stream, Malnadu TV India, News Gaon Se, Samvad Sarokar News, Bharat Post News, Gyan, as well as was shown live on Facebook and YouTube. And in our endeavor to bring to you every day new topic in media conference with Lal Goel at 10:30 a.m. Tomorrow our topic is siblings, love-hate relationships. Yes, you heard correctly. Siblings, love-hate relationship. And our panelists are Miss Karishma Chhatrapati, inner transformation coach, founder being spiritual with KUC, knowledge partner, Fitza Private Limited, Mumbai, Rotarian Dev Priya Uksa, renowned social worker, Jhansi, Advocate Nidhi Banga, Central Government Council, Delhi High Court, New Delhi, and as well as the Supreme Court, Rotarian Ritika Gupta, CEO, Mahasaraswati Hospital, Mathura, Miss Brinda Shine, research scholar, Periyar, Manimal, my university column. So please tune in tomorrow for media conference with Lal Goel at 10:30 a.m. Thank you very much, Advocate Jain. Thank you very much, Advocate Shashank Sudhi, as well as thank you very much, Advocate Anita Mahapatra, for giving your views and enlightening all our viewers. And thank you all the viewers for watching our show. Thank you very much.